Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Texaco v. Dahger. This case was heard in the Supreme Court of the United States in the year 2006. Let's go ahead and jump into the facts of the case. So Texaco and Shell are two competing entities, oil refineries. They provide gasoline to people. I'm sure you're quite familiar with both of them if you drive anywhere. Texaco and Shell wanted to, kind of break into the Western United States and do better in that market. And to compete in that market, they felt like it would be best if they began a joint venture. What this means is both companies, Texaco and Shell, would pool their resources and work together to kind of compete there, right? So they would both, share in any profits, share in any losses, operate one single entity that would sell gasoline through the Western United States. And so they named this entity Equilon. Equilon sold this gas, and then they sold it to certain service stations. They sold it to Shell service stations and Texaco service stations. Now these gasoline stations kind of began to get a little bit ticked off, right? They're like, well, Shell and Texaco are supposed to be competitors, and now they're together, working together, selling me gasoline out of this single entity, Equilon. And so they talk to some lawyers, and some lawyers dream up a theory of a case, and they say this is a violation of Section 1 of the Sherman Act. Well, what does Section 1 of the Sherman Act says? It says that it prohibits any contracts or conspiracies in restraint of trade. It's a pretty naked, bare bones common law statute, but as we know in the antitrust laws, it's kind of evolved. And what we look at is reasonable versus unreasonable restraints. Well, anyways, the plaintiff's attorneys for Dahger, the service station, say, this is illegal. This is not legal via Section 1 of the Sherman Act because this is price fixing. Texaco and Shell are working together to fix prices. Equilon sets the prices, but Equilon's board is made up of executives from Shell and executives from Texaco, and now they're working together. And when you have two competitors like this working together and setting prices, that's called price fixing under the antitrust laws. And so they argue this is per se illegal. Per se illegal means this is just flat out wrong. It's a violation of Section 1 of the Sherman Act. You don't get to rebut that presumption with any type of evidence saying that, this is actually pro-competitive, this results in efficiencies. They're saying, no, this is per se illegal price fixing. It's also important to note at the outset of this case that the FTC and a few other state attorneys generals in the West looked at Equilon. They looked at this joint venture between Texaco and Shell, and they said, you know what, this seems fine. On balance, this is okay. We're not going to prohibit this joint venture. And so Equilon functioned under a consent decree from the FTC and some other state governments saying, this is okay. We're fine with this. But the service stations say, no, it's not. And the district court, ultimately says, you know what, this is fine. Sorry, service stations. The FTC said it's fine. This isn't price fixing in the literal sense. This is, one joint venture setting prices, not two competitors setting prices. The Ninth Circuit Court of Appeals kind of reverses, and not kind of, they totally reverse. They say this is price fixing in the literal sense, and this is per se illegal, a violation of Section 1 of the Sherman Act. When you are a competitor, Texaco, and a competitor, Shell, you cannot work together to set prices on what you're going to sell gasoline at. And that's exactly what Equilon is, and so this is illegal. So here we go, massive damages, treble damages for the service stations. They have been wronged. Sherman Act Section 1 was violated, and Shell and Texaco are going to have to pay big bucks. And so what do? They get a good attorney, and they appeal to the Supreme Court of the United States. And that is where this case is ultimately heard. And this is a question for the court to say, is a joint venture that sets prices, is that price fixing underneath Section 1 of the Sherman Act? And the court pretty emphatically, 8-0, Justice Alito didn't participate in the opinion, 8-0, says no, this is not price fixing. Joint ventures, lawfully created, can set prices, and that is not price fixing in the sense of the Sherman Act. Yes, in a literal sense, and there's a line that says price fixing in a literal sense, this is, but it is not price fixing in the antitrust sense. That's what Justice Clarence Thomas writes, is this is not antitrust price fixing. So it is price fixing in a sense, but it's not antitrust. And why? Okay, let's unpack that a little bit. Well, Sherman Act Section 1 seeks to prohibit any types of, agreements between competitors where they're setting prices. But these two, Shell and Texaco, aren't really competitors at this point. They are functioning as one. They are teammates, essentially, It's like Batman and Robin. And now they are working together to try and, get into the Western United States and be successful. Although, say like it was Batman and Robin, maybe they had their own issues and they're fighting it out in the Eastern United States. They're competitors there. But in the Western United States, they're working together under this joint venture that the FTC approved. And so this is not price fixing because there's not two actors. There's one. It's Equilon. Equilon is setting the prices, and it's not a price setting between two competitors. That's essentially the reasoning of the Supreme Court's decision. And they say that joint ventures, when they set prices, it's not a violation of Section 1 of the Sherman Act. They can do that. That is fine. So that's really the case. I think it's interesting to unpack a little bit because you could see how this might look a little bit egregious. Shell and Texaco are major competitors, all right? And consumers, could possibly get gouged by increases of in the price of gasoline. Some argue, at least the petitioners for Dahger did, that gas prices went up 60% as a result of this joint venture. And so, maybe there were some negative effects. And then also something to really kind of just think critically about this. What happens when we get Shell execs and Texaco execs in the same boardroom? Yes, they are in a joint venture in the Western United States, but what happens when these guys and ladies, what happens when all these executives start playing, golf together, start going to each other's houses for dinner, start going to lunch out at these nice steakhouses, and they become great friends? Well, there's much more possibilities for price fixing in the illegal sense, where, Texaco and Shell are competing maybe in Texas, maybe they're competing in Florida, and now they're just kind of doing some price fixing there. And that could be wrong, but that wasn't the theory of the case by the plaintiffs. And, although it might lead to more of these contacts, those contacts on their face aren't illegal. What's illegal under Section 1 is an agreement to fix prices. And, price fixing, the Supreme Court says, does not exist when it's a joint venture and a single entity. So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.